with 2019 February question for evidence. It goes on to a second page, which is very rare for California. Let's take a look at the calls. Assume all appropriate objections and motions were timely made. Keep in mind, the only reason it says that is because of Federal Rule 103, where if you don't make an objection timely, you waive it. So they're just saying, all assume they're all timely made. That's all that means. And it's in almost every evidence essay you'll see. Number one, should the court have admitted Pedro's testimony? I assume that's the plaintiff. And because we have a plaintiff, I assume it's a civil case about her complaints to Dave about the leaks. Dave must be the defendant. She must complain to him. That probably has to deal with notice. B as in boy. Walt's testimony, Walt must be the witness, that Dave instructed him to caulk all the joints so that the water tank wouldn't leak. All right. Well, maybe it has to do with the effect on the listener. If I told you, well, how did you react to it? C, Gwen's testimony. I think she ends up being the gardener. The retaining wall was old. And number two, the retaining wall had structural cracks. I don't know about you, but when it comes to like property, there are people that can find structural cracks. Now, does everyone know how to find a structural crack in a property? Do you know how to look for them? Exactly. We're not experts. It's not something a lay opinion can probably give. So in this gardener, how would they know about structural cracks unless they have some kind of expertise, knowledge, or skill about it? So maybe that has to do with like expert testimony, lay opinion. Well, saying something's old, can a layperson give a description of something that's old? Right. You can say someone's drunk, the person was acting crazy, or they looked like they were very, frantic. These are all everyday things. Or, no, that car was going fast. Okay. The retaining wall had structural cracks that could cause it to fail and would cost $100,000 to replace. I would have thrown about that. D, Gwen's testimony about the plaintiff's reply. Well, if the plaintiff said it, can be used against the plaintiff. You're right. It's at least 30 years old. Okay, maybe that's an acknowledgement. And number two, which turns out to be a little bit of a crossover subject matter jurisdiction, which tells us this is not going to take you an entire hour. But again, this is probably going to be a very quick issue because it's at the end. Remember, the examiners front load the essays. So the least important calls are going to be around here. The most important is there. So don't rush to finish. A lot of people they see the clock and they want to rush to finish. And if you are going to do a time condition essay, here's a little psychological trick. Don't have your timer go from 60 to 0. Have it go from 0 to 60. It's a lot more psychological, soothing when you don't see like the counter go down. Have you ever seen an hourglass when you have to turn it upside down? And when you see it kind of running out, you're like, oh, well, have it fill up. It feels better and it'll calm you that much more. So when you're doing an essay under time conditions, I personally don't worry about time. I've got an internal clock in my head. And I know that I'll look at the clock maybe once or twice throughout the hour just to get it. I feel like I'm at the 20-minute mark. I might get 23 minutes in. And I kind of look at it towards like the 40, 45-minute mark. Because if I see like I'm on the 45-minute mark, 47-minute mark, now I know I got to wrap up. I just got to wrap it up. So let's say this is diversity. And I just have a few minutes. Parties are completely diverse. They're from different states, and the amount of controversy is satisfied. There's no federal question. Boom, I'm done. Like, I just got to get through it. So that's when you go to the heart of it. So you don't want to rush here to get here. You're like, oh, I got nothing to say. And that happens all the time because I see so many failing essays that have tons of issues right here, and they're nonsense because what they did is they rushed through it only to get to here and realizing, oh, I don't know what to talk about here. And they've kind of already shot themselves in the foot. So stay calm. I know it's kind of counterintuitive, but the slower you go, the better you're going to do, and the quicker you're going to get it done. That's why we go to the call. Take your time to understand what you're going to write, because it's a lot quicker to read this a second or third time than it is to write something that's not there. And it took you 8 minutes to write it. It took you 4 minutes to read it. I just saved you 4 minutes. See how that works? Okay. Answer questions according to federal law. Here we go. Dave is domiciled. There we go. Subject matter. This is why we go to the call first. And owns a house in California on the state line adjacent to Pedro's house in Nevada. Could be around Tahoe, probably North Tahoe. Pedro is domiciled in Nevada. So I already know we're going to have P, Nevada, D is California. Completely diverse. And since I already saw the $100,000 wall, I assume the amount of controversy is probably satisfied. You see how quickly we can already deduce that. And I'll tell you one thing, the fact that they've never tested federal question that I've seen on an essay, almost every time, I don't recall an essay ever testing federal question. Let's see. So Dave installed a large rainwater tank near the property line, which leaked. Okay, so Dave might be at fault for it, has to fix it. One day, the water tank fell over onto Pedro's property. Well, he's going to be responsible because it's foreseeable. That's part of negligence. Landing on her retaining wall, which buckled. Oh, now he got the oof. Tough one. Pedro sued Dave for negligence in federal court. So we know it's a state law claim. So we know it's not a federal question because it has to be a federal cause of action based on a federal statute. And I'm seeking $100,000. So we already solved number 2, which is exactly why we don't rush. So if you literally have 2 minutes to go and you still haven't gotten to call 2 yet, you still have enough time. You still have plenty of time because the parties are from different states, California and Nevada, respectively, and the amount of controversy is $100,000. The court has subject matter jurisdiction. There you go. Of course, you have to mention the $20,000. We'll talk about that in a second. So sued him for $100,000, replaced the retaining wall, claiming it failed because the water tank, weakened by leaks, landed on it. Okay. So failed the water tank, landed on the retaining wall. Yeah, probably all foreseeable, probably all part of the property damage suffered from negligence. At the jury trial, and because we're at trial, the rules of evidence apply. The rules of evidence apply only at trial, both bench trials and jury trials. Pedro testified, the plaintiff, that she had complained to Dave several times over the prior decade, 10 years of complaining, that the water tank leaked and that he had done nothing. So her complaints to D, and notice things are going to go in order. So this goes to 1A. Her complaints, well, that has to go with notice, like she's giving him notes of it. It doesn't necessarily, we're not using for the truth that it was actually leaking. We're going to show that at least she told him it was. So what did he do for it? And also notice it kind of almost goes to the effect on the listener. So effect on the listener, a better way of phrasing effect on the listener is it shows why the person reacted the way they did. It's like, why did they do or not do something? So if you told them, if I took my car into a shop and they said my brakes were faulty and I shouldn't drive, and I still drive, it doesn't matter whether or not my brakes were faulty. It just shows that I'm careless in not following the advice by driving with brakes that clearly should not be driven on, whether or not the brakes are bad or should be driven on. It just shows the effect that it had on me. And think about it, if somebody yells, he's got a gun, and you start running and you knock someone over, well, you could use that statement, he's got a gun, to show like why you acted that way. And you might have been reasonable in an emergency situation, acting like that. So that's why that statement shows the effect it has on you, like how you reacted after you heard the statement. So that's what effect on the listener is. Why did you react like that? That's another way of phrasing it. Okay. So now, could you use Pedro's testimony to their complaints to D as a admission by party opponent? Can you use that as a? The answer is no, because you can't use it for you. You can only, it has to be used by the opposing party, which is why it's called an opposing party statement, also known as an admission. So if she had said something to Dave and that Dave wanted to bring it in against her, that's fine, but she can't do it for herself. But however, like she couldn't, like I couldn't say, oh, well, I told the officer at the scene that I wasn't speeding. Well, that's hearsay. I can testify that I wasn't speeding, but I can't say, well, I told the officer. It's hearsay. It's not being used against me. Now, if I told the officer I was speeding, the defendant's going to say, well, you told the officer you were speeding. It's just being used against me. See, that's how party opponent admissions work. Something they love to test on, especially on the MBEs. Moving on. So when I discussed that here, maybe I'd put like a one-liner in. Like it's, but you know, as a side note, this would not be an admission by a party opponent because it's not being introduced by Dave, the opposing party. It's actually being used in Pedro's favor. Petra. Okay. So several times over the prior decade, the water tank leaked and he'd done nothing. She also testified the retaining wall was old, was only a couple of years old. So she testified that it was only a couple of years old. Then how could you possibly be?
The retaining wall was years old.
Oh, I'm sorry. The retaining wall was a couple of years old. The water tank was one old. Got it. Thank you. Good. I'm like, oh, that'd be impeachment. So she's giving her guess it would be lay opinion. How old? No, she said it's a couple years old. That's just personal knowledge. So with an evidence essay, and it kind of goes implied. So if I don't say it, it's because it's so minor, but you do the preliminary things. Relevance, personal knowledge. If you discuss hearsay in the first call, you don't need to define it again. You don't need to see above, just go right into the exception. All right. There's no reason to go relevance and define it again or copy and paste 8 times. The examiners are not doing cartwheels. And personally, I don't like the see above thing because it's kind of like I'm insulting. I'm like, yeah, I know, I just read it 2 paragraphs ago. So if you're writing an 80-page brief, different story. So everything you have to discuss, relevance for every call. Why is this relevant? It's relevant to show whether or not he knew and whether or not he was negligent in not repairing it. That's why it's relevant, or under 401, which is called logical relevance. Legal relevance. Well, is it highly prejudicial? Well, it's prejudicial in Dave's case, but the probative value is extremely high. So the only way the 403 would come in, meaning the unfair prejudice, is if the probative value is like 5%, it's substantially outweighed by the prejudicial effect, which means it's so highly prejudicial. It's like 95% prejudicial, and it has such minimal relevance in the lawsuit that it really doesn't get us any. So like the murder weapon, if like you find my DNA at the crime scene or you have my fingerprints on the murder weapon, now that's really prejudicial. That's extremely prejudicial in my case because it's going to show that I did it. However, it's extremely probative for the prosecution's case. So it's 95% probative, 95% prejudicial. It doesn't substantially outweigh it. Okay. So personal note. So you discuss, like, again, relevance one time, give the full definition, however you want to do it, and then just move on and say everything's relevant for one. Okay. She was training a couple years old. I'm assuming she can give a lay opinion. Okay. So opinion on that about the age of it. Pager then called Walter. And that goes to 1B because now we're down to Walter. A water tank repairman. All right, you might be an expert in the field. And again, for being an expert, you don't have to have a degree or a PhD or go to some liberal arts school and pay all that money just to show that you know gender studies. You could just like skill, experience, education, however you can obtain your knowledge and expertise. Who testified that when he repaired Dave's water tank, he testified that when he repaired Dave's water tank after it fell over, Dave instructed him, so because P's introducing it, now we have statement by party opponent because it's D statement. Okay. Dave instructed him to caulk all the joints so that it wouldn't leak. Dave instructed him to caulk all the joints so that it wouldn't leak. What do you think they're getting at there? Notice again. Oh yeah, subsequent remedial measures. That's just totally slipped my head. Right, because if it, and this is, it would not be admissible unless he says it's not. Well, it wasn't feasible to make the repair, but you just made the repair. So subsequent remedial measures about feasibility is usually tested with product's liability. So if a manufacturer says, let's say you said the product was defectively designed, and the manufacturer's like, well, there's no way we could have made that design. It's not feasible, meaning it's not cost effective. Just like a car 25 years ago wouldn't have a camera going in reverse because it wasn't feasible then. Technology hadn't advanced to the point where it was cheap to do so. So it wouldn't have been feasible. However, if they said it wasn't feasible to put like a camera in the car, and then they do it like months later, well, obviously it was feasible. So if they say that it wasn't feasible at trial, now you can show a subsequent remedial measure to prove that actually it was cost effective because you guys just did it. And that's only if they're saying it's not feasible. You can rebut them with it. So here we go. We have subsequent remedial measure, which is going to be inadmissible for policy reasons. Because what he wants to do is he wants to fix it so it doesn't leak. And it doesn't mean that he's admitting guilt that it did leak. He's just making sure it doesn't. And we want people to make repairs and not be punished by it. Okie dokie. So Paige arrested her case. So she's finished with her case in chief. It feels like I might be missing something. Let me know if I am. Moving on. Dave called Gwen, Petra's gardener. who testified that she had met with Pedro the day before the water tank fell. And while they inspected the retaining wall at issue, she saw it was old. All right. Well, old seems like we're getting at my opinion, which you can probably make. So something doesn't work out there if they're doing it twice. And had structural cracks that could cause it to fail. Structural cracks. How, I'm not saying Gwen doesn't have the expertise, but in order to give this opinion, because this would be an expert opinion, so it's giving expert testimony, somehow G would need to be qualified as an expert in order to testify to structural cracks, because this is not something the average person knows how to find. You have to have some kind of special skill, talent, knowledge, experience in order to be able to understand that. So I doubt that part will be admissible unless she gets qualified by the judge by a preponderance of evidence. For some reason, the examiners love testing that on the MBEs. Experts are qualified by the judge using the standard preponderance of evidence. Very heavily tested. Testified she met with Pedro the day before the water tank fell, and while they inspected the retaining wall at issue, she saw it was old and had structural cracks that could cause it to fail. Pointed this out to Petra, and told her that it would cost at least $100,000 to replace it. Huh. What does anyone see going on there? Anything you see going on? Aleko?
So would this be more about like the impeachment for the prior inconsistent statement, because she was saying that it was like 10 years old and then 30 years old? And
exactly. So Peter says, yeah, it's at least 30 years old. Somehow they don't, I guess they're talking about Gwen's testimony, the retaining wall is old. And they thank God they say that because they kind of point out what the issue is, exactly what Aleko mentioned. So if Pedro replied, and again, now we have a party opponent now, and again, it seems like the same thing again, being used against her, because Dave's called the witness. It doesn't matter if he called the witness, but it's being used against her. And the fact that she said it was 30 years old, so this is impeachment by what? A prior inconsistent statement, I guess, because she tested, but it doesn't seem right because of the out-of-court statement. So the fact that, and it can be used substantively and for impeachment. Why can it be used substantively? Because it falls within a hearsay exemption of party opponent. So not only that, you can impeach and use it substantively for its truth, dealing with how old the actual wall is.
Jason, does extrinsic evidence, was there something regarding
extrinsic evidence for impeachment? The only thing you're thinking about giving somebody the opportunity to explain or deny. But that doesn't apply to parties because they're a party, they're going to be there the whole time. It only applies to, somebody but not a party. So what he was asking was prior inconsistent statement. In order to introduce extrinsic evidence of a prior inconsistent statement, you have to give the witness the opportunity to explain or deny it. And you can't introduce the prior inconsistent statement until after the witness it's been brought to the witness's attention. Now, that's the new rule. It's been amended. I want everyone to understand that. So a prior inconsistent statement it used to be any time during the trial, but now you can't even introduce the prior inconsistent statement until after. Well, you can't use extrinsic evidence for a prior inconsistent statement until after you ask the witness about it on cross. Now, the judge has some discretion to override that rule, but in most cases, they're not going to be able to introduce it here, but it doesn't apply to parties. It only applies to witnesses. And the reason is because the party's automatically there. They can always recall themselves. David?
Yeah, we're using Petra's statement about the wall being 30 years old to impeach her previous statement of it only being a couple years old. Is that right?
Yeah, she testified earlier that it was only a couple years old,
right.
And she said to Gwen it's at least 30 years old. So then we got the impeachment, which is a clever way of testing impeachment in a way, but they do say the call about being old. Structural cracks deal with experts. And the last paragraph, which will go to call 2, as you can see, the first paragraph and the last paragraph go to call 2. The second paragraph about Dave installed the rainwater thing, that's part of setting up the case. Then we have Pedro's testimony, which is paragraph 3. Then we have Pedro called Walt, which is 1B. So we have 1A for the third paragraph, 1B for the fourth paragraph, 1C for the fifth paragraph. And then 1C and 1D for that paragraph. So again, each paragraph, so it's like a mini hypo. When you look at these essays, think about the examiners do that all the time. They'll break things up into paragraphs, or they'll really kind of section it off if you look for it. They'll do that so many times on essays. And things go right in order. So the last paragraph goes to call 2. The jury returned a verdict in favor of Petra and awarded her only $20,000 in damages. So one thing about this is the fact that she only got $20,000, does that retroactively defeat subject matter jurisdiction? The answer is no. And for obvious reasons, because if you get less than the amount, the 75,000, which is going to happen in many cases where it's $100,000 case or something like that. Well, now if that rule didn't apply and it would defeat jurisdiction, we'd go through that entire trial, years of work to go, yeah, we didn't have jurisdiction, we got to do it all over again. So it makes no sense. So that's why if jurisdiction existed at the beginning, it's going to last throughout. I mean, for the most part. 20,000, so it won't retroactively defeat subject matter. So Dave filed a motion to dismiss based on lack of subject matter. And they're really trying to hint at that 20,000. Notice that. They're really hinting at that. Like, why is he doing that? Well, because he's trying to say that, well, you didn't meet the amount of controversy. That's obviously not true, which was denied. And Dave properly appealed the verdict, which means he did within 30 days. You have 30 days to appeal. And there you go. Oh, yeah. 30 years old. Okay, that's why I didn't see it. That's where. I'm like, why didn't I see it here? Because this actually went there. There we go. Okay, and that's a wrap for the 2019 February question 4. All right, I'll take questions on them. Let's see what we got. Sargis?
Jason, would you
cut the
also
recording at this point? Go ahead.
would you also be able to bring impeachment by bias or interest?
Not really, because she's a party. And that's kind of implied. Like, who would be biased?
Petra's Gardner that testified that the water tank fell.
Who's the Gardner biased for?
For Petra.
Who testified against Petra? The Gardner really kind of
right,
Petra on the bus.
Right.
Yeah. David, and keep in mind before I answer David's question, if you see an answer choice on the MBEs that it's the evidence is not admissible because it's self-serving. All evidence is self-serving. You wouldn't introduce it if it didn't help your case. So that's not right. Everything's self-serving. I mean, why would I bring in evidence that's going to hurt me? I'll let them try to find the dirt. Okay. David, go ahead, bud. David? All right. I think we lost him. I don't see him. All right, Gunji, what do you got?
What was the rule, Jason, where you said expert opinion comes in if there's a by preponderance of the evidence? Is that
So
like
in order to testify, to give expert testimony, before you give expert testimony, the judge has to qualify the witness as an expert, and the standard is preponderance of the evidence.
Okay, got it.
So the judge has to be convinced that more likely than not, you can give an opinion that's based on scientific technical data. You use reliable methods, and you reliably apply those methods to the facts of the case. There you go.
Okay, nice.
Okay. What else do you guys have? Did I miss anything on this one? I don't feel like I did. I feel like I missed one little thing. I don't know why. Go ahead, Viviana.
Would we bring up the legal certainty test for subject matter jurisdiction just because they include the fact that Gwen told Petra that it would cost at least 100,000? Is that relevant?
No, because the legal certainty thing is, I mean, they might have only because she could have got $100,000 if the condition of maybe the water heater was better, or the retaining wall, or maybe whatever wasn't 30 years old. So the jury probably just looked at it and go, okay, maybe a new wall is 100,000, but out of the age, it's declined, kind of like a car, you're going to depreciate it. So maybe the jury did something like that. So no, you wouldn't bring that up. The legal certainty thing is, if I sue you for, let's say, $50,000 in damages for negligence, and I ask for another $50,000 in punitive damages, well, I cannot in any situation recover more than $50,000. Does that make sense? You understand that? Why can't I recover more than $50,000?
you can't collect those punitive
Yeah,
damages.
because punitive damages are unrecoverable as a matter of law for negligence. So if I'm only asking for 50, it's legally certain that I cannot get more than 50. So that would be a situation for it. And I almost never see that legal certainty thing tested, I'll be honest with you. I can't remember I've ever seen it tested.
Okay, cool. Thanks.
You got it. Olivia.
Would it be incorrect to raise present sense impression for
For what?
when they're talking about the wall? Like while they were inspecting the retaining wall at issues, she said it was old.
Yeah, absolutely. God, this is why we got that checklist, because that's part of the top 10. I'm like, how did I fucking miss that? You're right. They're looking at it. They're observing a condition or an event or a condition as they're looking at it. I don't know how that thing got over my head. Now keep in mind something. A present sense impression is a statement describing an event or a condition while you're perceiving it or immediately thereafter. Think about that for a second. Now hearken back to the essay we did the first week of class with that guy in the courthouse, Wes, that said, oh, he's the guy. Whoever did the killing, murdered the guy taking the drugs on the old desolate road. Why was that not a present sense impression? I mean, he's describing it as he's watching it. How is that not a present sense impression? For those
Because
of you
it
that
was
don't
an
know,
excited
I'll answer.
utterance.
What's that?
Wasn't it an excited utterance?
It wouldn't be excited utterance either, because that's also describing an event or a condition. Why would him going, oh, that's the guy. No, so he sees him, he's watching, he's seeing him right now. Like, I see you. I'm like, dude, that's him. Like, I'm looking at you and I'm describing it as I'm actually perceiving it. You have to speak up.
Sorry.
Testimonial?
Testimony because it's
No.
happening now.
No, it's not proof past criminal conduct.
Can you do that for an identification?
You can't use a present sense impression for an identification. And for those of you that don't know that, tell me you didn't review the model answer carefully, because I put a big note in it about that, why it's not a present sense impression, which tells me you're not reviewing carefully. And if you're like, oh, well, that was weeks ago. Yeah, you should remember it. That's why you review so carefully, so you do recall, because that should have stuck out in your mind going, oh my God. Like, because I even had why is it not a present sense impression? What am I missing? Just like, why was nuisance not an issue in that one real property essay? Oh, because it's against the landlord, not against the actual tenants. Got it. That stuff should stick in your head. And it really should. I'm sorry, but it really needs to. And I know you can't remember every little thing, but certain things you got to remember. So, and that's why I can't stress enough about reviewing. And you guys are going to roll your eyes and look the other way and go, yeah. I'm just going to do the issue spotting. And essays aren't going to go well. And I'll tell you what I'm worried about for the exam. People, you guys will read the essay one time. You won't control your shit. You won't stay calm. You're going to go over time. You're going to shoot yourself in the foot. Because bad habits are hard to break. And if you're used to skimming things or not looking at things or not managing your time properly or looking at all three essays before you start, because a lot of people look at all three to which one they want to do first. Don't do that. Or they'll read them. They're like, oh, you're wasting so much time. And then you complain about you don't have enough time. Well, you just wasted 8 minutes reading all three to determine what you were going to do first. And I'll explain to you why that's such a terrible idea. Why is that such a terrible idea? Because let's say, what's one subject you don't like? Property. So you look at all three essays at once and you see, oh shit, essay 2 is property. So what's she going to do psychologically? First of all, she can be thinking about that real property one when she's doing the crim law one, which you love or whatever. And you're not going to stay focused. You're worrying about nothing that you don't even know what's going to go on. And because people like to procrastinate, it's human nature, you're going to spend extra time on what you know because it's more comfortable, and you're going to leave less time for the real property one, and now you just shot yourself in the foot. Instead of just taking things in turn, 1 hour, 1 hour, 1 hour. I'm giving you the playbook of what it takes. Use it. And if you think you know, and so many of you, remember I said don't use logic, they know better than me. Because they had a friend that passed, 400,000 people passed. Okay, come on. Everyone's going to have a different opinion. But at least my opinion is an expert opinion. And I'm telling you what works and what doesn't. And I've seen it all the time. And you know what I see? People that don't review carefully, take the bar over and over and over again. Case in point, this guy was in my course. He had failed the bar 22 times. I think I might have told the story. Let me tell it again. Maybe it'll sink in. And I said to him when we met up, he was in the class, really nice guy. And I said, okay, Doug, what is it? Like when you look at your answer for what you wrote on the bar and you compare it with the selected answer or a model answer that you have from a different course or a book, I go, what do you see you doing wrong? He goes, what do you mean? I go, well, what did the answer say? And what did your answer say when you compared the two? I've never done that before. I'm like, what? What do you mean you didn't do that before? Because how are you going to troubleshoot if you don't look at what's wrong? And he said to me, well, nobody ever told me to do that. And I just said, oh my God, you wouldn't know to look at the answer to figure out what the answer is so you understand whether or not you got it right or wrong. And you guys, some of you are just so arrogant. You're like, well, I know I got it right. I had one girl say that to me. She goes, well, I knew I got it right. I'm like, because you're asking me what this is based on. I go, I actually listed the case and the answer. How did you not see that? I go, did you read the answer? She goes, yeah. I go, did you actually read the answer? She goes, yeah. And then it turned out, no, she only read the one little part that she thought she missed. Oh my God. And she didn't realize, because here's the thing. And for those of you that ever call me to go through anything with me, what do I do whenever we go through something? I look it up on the spot to make sure that I'm giving you the right answer. I check myself all the time. I don't assume I know anything. I assume that I'm going to be wrong. So even with this, I'm like, okay, what did I miss? I'll go to the answer and make sure I see what I missed. I'll see make sure I got, and also I want to make sure that I got everything correct as well. So review. And the people that don't review, I mean, you're going to have tremendous problems with the essays. And I know you think you know it, but you don't know until you don't know, which is why I said, who here has ever shopped at relentless.com? Because you thought you knew the answer. And it turns out you didn't. You're positive you didn't. I was positive you did. All right. So I did it the first week to let you know, don't be arrogant. I mean, the streets are littered with paralegals that try to take this exam that thought they were smarter than everyone else. And don't give me this, I've never failed a test in my life bullshit. Everybody who's gone to law school never failed a test. You know who failed tests? Well, you see them with the mob, all right? Or they're in the drive-through. Those people fail tests. You guys haven't. That's why you're here. So if everyone here has never failed, that's like saying, well, I was a star athlete. Yeah, guess what? Every guy on the bench in the NBA or the G League or in AAA or AA, they were a star athlete in college, in high school. And when they're Pee Wee League and Little League, all right? But they didn't make the big, now we're in the big times, and this is what this test is. It separates the good from the great, or separates the average mediocre from the terrible. Because honestly, I think the test has gotten way too easy. Okay, so review. And why does a present sense impression not apply? Because, as I just explained, it's describing an event or a condition, not a person. There's a separate rule for that for prior IDs, and you have to be on the stand and subject to cross. That's why. Because the rule says explaining an event or a condition. It was cleverly written like that, not a person. So that's why present sense impressions don't apply to people, but they do to objects or events. There you go. Interesting point. Okay, please review.